These appeals are supported by the Anti-Trafficking and Labour Exploitation Unit. The appellants are both Nigerian women who were brought to this country as migrant domestic workers and were treated very badly by their employers. They were both made to work hard for long hours. They were not given the time off required by law. They were not paid the minimum wage, and they were not given written particulars of their contracts of employment. Both had their passports taken away from them when they arrived in this country. Ms. Taiwo was not given enough to eat and was abused both physically and mentally by her employers. Ms. Onu was also threatened and abused by her employers and told that she would be arrested and imprisoned if she tried to run away. Eventually, they both did manage to run away and were helped to bring claims in an employment tribunal against their employers. They succeeded in getting substantial awards for the wages they should have been paid, and lesser sums for the failure to provide written particulars of their contracts and the required rest periods. Ms. Onu was also awarded a substantial sum for unfair dismissal. But these sums did not provide any compensation for the humiliation, the fear, and the severe distress which such mistreatment can cause. In addition, therefore, they both complained of race discrimination, which includes discrimination on grounds of nationality. In Ms. Taiwo's case, the tribunal found that she had been treated so badly because she was a vulnerable migrant worker. In other words, because of her particular immigration status, but not because of her nationality. So they dismissed her discrimination claim. In Ms. Onu's case, the tribunal also found that she had been treated the way she was because of her migrant worker status, but held that this was clearly linked to her nationality, and so upheld her discrimination claim. The Employment Appeal Tribunal dismissed Ms. Taiwo's appeal and allowed the appeal of Ms. Onu's employers on this point, holding that this was not discrimination on grounds of nationality. The Court of Appeal agreed. The issue for this court is not whether these appellants deserve to be compensated for all the harm which they have suffered. Many people would think that they do. The issue is whether they were treated as badly as they were because of their nationality. The Equality Act 2010 protects people from discrimination on grounds of their nationality, but it does not protect people from discrimination on grounds of their particular immigration status. The question is whether immigration status can be equated with nationality in the sense of not having British nationality for this purpose. This court unanimously dismisses these appeals, not because these appellants do not deserve a remedy, but because immigration status cannot be equated with nationality for the purpose of the 2010 Act. Many non-British nationals living and working here do not share the particular vulnerability of people working here under migrant domestic workers' visas. They would not have been so badly treated. The treatment of these appellants had nothing to do with the fact that they were Nigerian and everything to do with the vulnerability flowing from their immigration status. Parliament has not chosen to make immigration status a protected characteristic under the Equality Act, and one can understand why. Parliament might, however, wish to consider extending the limited right to compensation which is given by the Modern Slavery Act 2015, so as to enable the people covered by that act to claim compensation in an employment tribunal at the same time as their other claims.